Kenneth attorneys, law students, let's get to it. Part 2. So today we're talking about ex parte applications. We're going to talk about ex parte in match court, ex parte in high court, right? So the first thing, you need to be able to define what an ex parte application is. Define it, simple definition. And then once you've done that, it's important that you know that in the match court, ex parte applications are regulated by Magistrates Court Rule 55 subsection 3, right? We're in here. It basically also just defines it for you, and they also say that an ex parte application is necessary when giving notice would defeat the purpose, right, of the application. And then also the degree of urgency is so great that dispensing of the notice is justified. Okay, cool. We're revising. This is not studying, we're revising. We're seeing how much we know. We're going over important concepts and highlighting things that you need to so ex parte in the high court. Two instances. When the applicant is the only person who is interested in the relief sought, right? That's number one. Number two, when the relief sought is a preliminary step. Remember, breakdown words: preliminary, meaning prior, opening, preparatory, initial. So in what instance, for example, would the relief sought be a preliminary step? There's a couple of instances. One of them is edictal citation, substituted service, attaching property to confirm jurisdiction. 3. Edictal citation, substituted service, and attaching property to confirm jurisdiction. On that note, let's pause. Do you still remember jurisdiction? How we determine the court that has jurisdiction? That is very important. They like to ask that as an essay question. You need to be able to flesh it out. The applicable principles, the applicable rules, the kilometers. Please don't think that that's something that you have to leave in law school. Jurisdiction is very important. It's something that you'll work with every day if you go into practice. Okay, so let's talk about defective pleadings. There are 3 ways in which one can deal with defective pleadings, right? And these 3 ways are exception, application to strike out, irregular proceedings, right? Application to strike out, irregular proceedings, exception. Now, when we look at exception, there are some subcategories under that. There's an exception would have said, we can say an exception has taken place when the pleadings, right, are vague and embarrassing, and when the pleadings fail to disclose a cause of action, right? Which rules regulate these in the respective courts? So in the Magistrates Court, we have Rule 19, subsection 1. Read that, please. And in the High Court, we have High Court Rule 23, subsection. Okay, so let's talk about shortcut judgments. There are 3 kinds of shortcut judgments, right? One is a default judgment. Second, summary. Third is confession or consent to judgment, right? So let's flesh out default judgment. What's going on there? So when a party to the matter fails to do either of the following, then you can apply for a default judgment. When a party to the matter fails to enter an appearance, when a party to the matter fails to plead after being warned to do so, and when a party to the matter fails to appear. Say that there's 2 types of default judgments. One is when there's a default in appearance, and when there is a default in pleadings. On that same note, while I'm just going through my old notes, it's important to know that for this section, you need to know how to draft a notice of bar. You need to know how to draft a rescission of judgment. The rescission of judgment question they love, especially with in conjunction with the NCA for paper 1, National Credit Act, NCA. So notice of bar and the rules that are applicable with a notice of bar and the rescission of default judgment. The rescission of default judgment. Remember that a notice of bar you would use when you're barring someone from entering further pleadings. But when does that happen? Check it out in match court and check it. Summary judgment is awesome, short, sweet, and straight to the point. With a summary judgment, you can apply for a summary judgment in the following instances: when you're dealing with a liquid document, when you're dealing with a liquidated amount, or for the delivery of specified movable property, or for ejectment. Liquid document, liquidated amount, delivery of specified movable property, and ejectment. They might ask you to draft something in this regard. Please look at past papers here. Okay, let's talk about provisional sentence summons, right? Provisional sentence summons are regulated by Magistrates Court Rule 14A, capital A, and High Court Rule 8, right? So how you should approach looking at provisional sentence summons is what makes provisional sentence summons so special. And they like to ask this where they give a situation, they're like, a check for X amount, that bounced, how would you advise the client? There's a reason why provisional sentence summons is special. What makes it special? All I can say is it helps you to cut the line. You don't have to deal with the hectic court roll. In terms of drafting, just to wrap up, in terms of drafting, when we're looking at particulars of claim, there's a number of POCs, particulars of claim, that you need to know how to draft. Particulars of claim in regards to a motor vehicle accident, right? A loan, reclaiming of a motor vehicle, and breach of contract. You need to know how to draft the particulars of claim in each of those instances. Those get asked every year, if not every second year. Those particulars of claim. And don't be fancy. Put in the details that you need to put in. There's no need to go out and about. Even if you use 12 Red Street, John, a teacher employed at Red Hill School. Don't be fancy, because you are going to be pressed for time with this exam. And another thing that one needs to look at is you need to look at a letter of demand, right? It's something that's so basic. Because remember, before you start legal proceedings, you always start with a letter of demand, and then you start the legal process. It's very important to know that. Please know how to draft a proper letter of demand that has enough information. That can also be something like a 10 to 20 mark question, maybe. And then when you're talking about letters of demand, it's important to look at section 127, section 129 of the NCA. You need to know how to draft those two letters, section 127, section 129. They might even ask you to draft a combined letter. Those of you who are candidate attorneys in banking would have an understanding of what a section 127 is and what a section 129 is. Awesome source. And then lastly, when we're looking at jurisdiction, I think I spoke about it a little bit earlier on, you need to make sure you know the rules when it comes to jurisdiction. It's a great essay question. Awesome.